Welcome to another legal talk here on eRadio with Hahn Hahn Attorneys, and today it's my pleasure to welcome back Merilynn Du Plessis, Senior Associate Attorney at Hahn Hahn, who joins us to talk about something very interesting once again. Merilynn, welcome back.
Thank you, Ian. Hi, and hi to all the listeners. I've missed you all.
Yeah, it's so nice to chat to you again. And today we're talking about NERSA's method of approving the increase of municipal tariffs was declared unlawful. Can you give us a bit of an introduction there, Merilynn?
Sure. Okay. So last year, July, AfriForum brought an urgent application against NERSA for declaring the methodology of determining tariff increases invalid. And the crux of the case is that the methodology of increasing tariffs for municipalities affects people and businesses and what they pay for the electricity. So just to give background, NERSA is an energy regulator. They are the body that has to approve tariffs calculated by the municipality. So, for instance, a municipality cannot just charge what they want to. NERSA has to approve that tariff. And in going into that approval of tariff, there's a lot of things to consider. And what happened here is, so NERSA has to consider and they have to approve the tariffs that the municipalities charged. And currently, it should be charged on the cost of supply methodology, which I will explain a little bit later. Okay. But it's basically the total expenses incurred by an electricity distributor or a utility service provider. So your cost of methodology would be the exact total expenses versus adding on or making it a discriminative, etc. Okay, so this matter goes back to a court decision in 2023 already, where the court again, or the first time where the court declared NERSA's methodology invalid. At that stage, they applied a methodology called benchmarking. And at the time, the court gave NERSA and the municipality 12 months to rectify the position. So in other words, it declared it invalid and said to the municipalities, NERSA, you've got 12 months that we won't apply this to you. So you've got 12 months to correct your house, and then it will apply. At that time, NERSA was applying the benchmarking methodology. Now, the benchmarking methodology is a manner which NERSA tried to ensure that all municipality tariffs don't differ too much. It can be very problematic. For instance, if you take the benchmarking methodology, you apply it to a huge city, so you base it on big cities, and you apply that throughout the countries, you can imagine what the small country residents and tenants would be paying. They'd be paying for tariffs that are based on big towns with huge consumptions. So that I think is a little bit important to understand.
All right, okay, Jana, it makes perfect sense, Merilynn. Thank you. And I also want to ask you, on what basis was NERSA's methodology declared invalid?
So after this case that I referred to in 2023, it came to light that NERSA was no longer using the cost of supply methodology, but used now another methodology called the assumption methodology. And I think that I don't really have to explain the assumption methodology because I think the name says it all.
Yeah.
Based on assumptions, and this was done through a letter sent out by NERSA, having light of this assumption methodology. And I think it's important for the listeners to understand that, we already know that electricity prices is already high. Basing it on these methodologies, on, for instance, an assumption, you cannot do that because, obviously municipalities will have ultimate control of guesstimating anything and asking NERSA to approve those tariffs based on assumptions. So NERSA sent out a letter indicating to the municipalities that is how they are now going to decide what the tariff increase should be. During the court considered this correspondence and held that it was clear that NERSA was, after the 2023 case, increasing tariffs on the cost of supply methodology, but changed in January 2024 to this assumption basis. So what's important is the cost methodology stems from the highest authority, let's say the executive authority. So how all our electricity is set up is based on the electricity policy pricing, which the executive has created, and according to that policy, all increases of tariffs must be based on the cost of supply. So now I can delve into the cost of supply study for everyone. So the cost of supply study serves as a dual function. It first ensures that municipalities efficiently distribute electricity. If municipalities are charging more than the cost of supply studies indicate is necessary, they are not providing services efficiently. So your cost of supply is exactly that. It's based on your exact costs to distribute, to generate electricity, nothing more, nothing less. Okay. But having said that, they are municipalities are also have the right for a certain markup percentage, but that will include for technical losses, etc. So municipality licenses subject them to be efficient, and I think I think that's one of all of our concerns is efficiency right now. So a cost of supply study allows NERSA to test the efficiency of the municipality's electricity distribution. The second is to ensure that there's a standard and transparent processes for end users to engage. So they know what they charge, that they've been charged, they know how it's been charged. There's no such thing such as bundling. Some municipalities actually bundle tariffs, which means you get an account and your account line says electricity and there's a ridiculous amount on it. And what they're going to go and do is they've added they've placed the NERSA's approved tariff plus the ownable levy plus this charge plus that into one charge. So the cost of supply eliminates this.
Okay, Merilynn. And what is the effect of the different methodologies adopted by NERSA on us, the consumers?
As I took you through each methodology, the assumption and the benchmarking methodology would have the effect that the end users would have substantially overcharged. It would be unfair and it would be completely discriminatory, like I explained about small town and the big towns.
Okay. And also, was there any pushback against declaring that methodology invalid or not?
Definitely. So Salga was on this case. They acted on behalf of the municipalities, and their position was, so let me just say this first. I think about 160 municipalities were compliant at that stage. But Salga's contention was that the non-compliant municipalities had already approved their budgets based on the unlawful methodology. And if they are prevented from implementing their budgets, it would not only cause financial hardship, but it will cause many of the municipalities to go bankrupt. The court, thankfully, smart enough, said to explore this. Well, Salga actually requested Salga requested 12 months to have municipalities be compliant. And that means to give their cost of supply to NERSA and NERSA to approve it. Fortunately, the court rejected this because in 2023, a case was already given where a grace period of 12 months was given to municipalities to have their houses in order. So they have had much time to have their houses in order, and therefore it wasn't granted.
Okay, interesting. And then finally, Merilynn, what was the outcome and what does this mean for municipalities and eventually the end users as well?
I think this is where the big bang comes in. The effect is the court has declared all tariffs that the municipalities charge that have been based on the cost, based on anything except for the cost of supply methodology, with no force and effect. And they are not allowed to approve or consider for this year and any other years to come where the municipalities has not submitted cost of supply and where tariffs are not based on cost of supply. And now to remedy, to help those people, because obviously now you'll have instances where for this year and last year, municipalities have been charging on those incorrect tariffs. And what that means for us is that for all those municipalities that have been charging on that tariff, has to charge on the previous tariff of 2023 until they become compliant.
Absolutely. Merilynn, thank you so much. This was very, very interesting and we really appreciate it and it was nice to chat to you again.
It's a big pleasure. I hope everybody has a warm night and day.
Thank you, Merilynn. And that was Merilynn Du Plessis, Senior Associate Attorney at Hahn Hahn for this week's Legal Talk.
Are you or your business in trouble and struggling to find a solution? Call Hahn Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn Hahn Attorneys, Wednesday mornings at 10 on eRadio.